best discussed as an open item. There may be some feeling that it should be an executive session item. If it is to be an executive session item, we would need a motion, a second, and a vote to go to executive session to discuss it.
Can I just speak to that briefly?
Sure.
I've been following the decisions from the local Supreme Courts in the area, and they've been very harsh on municipalities that are violating the open meetings law. They've been sanctioning them in the form of awarding attorney's fees to the prevailing parties when towns violate the open meetings law. So I think we have to be very careful from now and into the future in how and why we go into executive session. If we're talking about a specific individual, an employee, that's fine for executive session. If we're talking about a litigation tactic and some lawsuit we have ongoing, I think that's fine for executive session. If we're talking in terms of just general concepts, when there's no actual pending litigation, I believe to be safe we should stay in an open meeting. I believe what they're trying to ensure is that local government is transparent as possible to the people.
So you wouldn't consider this litigation?
At this point, there isn't any pending litigation that I know of. A lawsuit's been decided. To my knowledge, no notice of appeal has been filed. So, there's no pending litigation. I'm just saying we're treading on thin ice when it comes to this. There's an attorney in Springfield that in the paper just won a good sum of attorney's fees for violation of the open meetings law. Open meetings law.
Well, if we've, and I'm suggesting that as per our minutes from last year, Dave Bocci is the attorney for the moratorium.
Correct.
Should we get his opinion also? I mean, I'm not sure what he is going to tell us, so I'm not sure whether it should be or shouldn't be.
Yeah,
I know it's
Well, I
here.
can tell you, I'm satisfied with Joe's determination that he's our town attorney. He should be the one that advises us on how to do things.
I understand.
Good with it.
And Dave Schlatsky is the attorney on record for the moratorium. So I'm just getting a second opinion, that's all.
What if we get David's opinion on it, and then we'll decide after that.
That's fine.
So he doesn't need to
Yeah.
make his full presentation, we can speak to that.
Yeah.
My opinion is that this is absolutely a litigation matter and falls squarely within open meetings requirements and similar requirements for going into executive session.
Does that mean you're recommending an open session?
So I recommend going into executive session to discuss it.
And could you identify yourself? Who are you?
My name is David Slapche. I am one of the lawyers on the moratorium.
Thank you.
Again, I think this is a matter for how the supervisor conducts the meeting. And as far as I know, and you just heard it from counsel, that there are specific reasons why you go into executive session.
I believe litigation was one of the reasons.
Well, just a one-word answer isn't the answer. I think this does not appear to qualify for that. You just heard that there is no litigation going on at this point, or at least there's no litigation that I'm aware of.
Is there an appeal underway at the moment?
One of the matters that I thought we were going to discuss in executive session is the town's appeal options. That's what I came to, among other things, I came to discuss tonight.
Is there an appeal underway at the moment?
We would not file an appeal before the board said to file an appeal, so no.
And we would need to discuss the whole issue with the attorney in order to make that determination whether we're going to appeal or not appeal. We haven't made that decision yet. we have not been advised by him whether we should or shouldn't. And I don't think that should be discussed in an open meeting.
And my understanding of town law is that normally we are guided by the town's council on a point. If I understand things correctly, it is the prerogative of any council person to make a motion, a second, and take a vote as to whether an executive session transpires or not. So what I'm saying at this point is, if there's a strong feeling on this board that there needs to be an executive session on this point, you will need a motion, a second, and we need to take a vote.
Do you wanna like do 7, 8, 9, 10, 11 before you, because everybody here is gonna wait throughout the executive session to come, can I make a decision in executive session? We would have to come back
Right.
and make a vote and then try to continue. I just, there's a lot of people.
I don't think that's the material issue. I think this is too important a matter, I think, to make an adjustment on the basis of, I don't mean to to throw monkey wrench into this whole group here either, but I think the overriding factor here is whether we go into executive session or not. And again, I think it's pretty clear, you've heard it from your own counsel, that we do not go into executive session. Now, what's the risk of doing it in the public, as opposed to the downside of doing it in executive session and being found that you did it improperly?
Can you give us some more information on that, David?
One of the litigation exception with respect to executive session is designed to deal with things like strategy and tactics. There is litigation going on. The town has a right or has the ability to appeal if it would like to. And
An appeal is considered litigation.
absolutely, you are appealing the litigation below. So I don't want to, I don't know what to say except if you're going to discuss an appeal, there is litigation by definition. There's nothing to appeal except litigation. If you have decided not to appeal, that's fine, and in which case somebody should tell me and we can go on.
And I think,
But there's no appeal presently in process. There's not anything at this point in time of a legal nature that's transpiring on this matter.
No, had we appealed without you talking to you, there is no appeal unless and until this board decides it wants to appeal.
And the local law was deemed invalid, correct? So there is no local law. So there really is nothing right now. Nothing,
well, that's
right now. Right now, there is nothing.
Make the motion.
We have an option to appeal that decision,
Yeah.
so there's something. And
Yes.
that's what he is here to discuss with us, is what our options are.
Yeah, strategy and tactics are something that should be discussed in executive session. If there's some strategy or tactic that you don't want to tip off your adversary to.
Well, if we have not been approached by our lawyer that argued this case as to what our options are, because the decision came in against us, would that not be considered strategy?
No,
He's here to discuss our options.
Yeah, I read his letter. I agree with what he stated in his letter as far as our options are concerned, but they're no big secret. There's no strategy or any special technique involved there. It's that's just the truth, what the options are.
Make the motion.
There's nothing secret that we'd be worried about tipping off an adversary to.
One of the things that I intended to talk about is what was discussed, including specifically what Mr. Ermetti said. in the last executive session that this board held on this, that I attended. And it may or may not be relevant to the board what the lawyers think, and what Mr. Armetti himself said at the last executive session may be relevant, to whether or not the board wants to appeal. But I absolutely think that that is something that shouldn't be said in open session. And couldn't be. I mean, Mr. Armetti said what he said in executive session, so.
I don't remember saying anything.
I do, and I'll repeat it in executive session, but if I repeat it here, then I'm breaching the law. Because everything that's supposed to be said, that's said in executive session is supposed to stay there.
Matter of logistics. We will have another item further on the agenda to go into executive session. Are we further ahead to deal with both matters at the same time, which would be a more extended discussion?
That's what I said.
And then are we further ahead
No.
to go ahead with the rest of the agenda and save the executive session to the end?
I don't think we should mix them. I think, I'm not sure what we're going into executive session for otherwise, but, you know, you're being advised to do it in a certain way, and as far as I know, I'm not the lawyer on this whole thing, but as far as I can see, you're getting advice from the person who also said it was the right way to do it, when in fact, the judge is saying exactly the opposite, that it was done improperly. It wasn't done right.
So we are getting into directly the matter that I wanted to speak about in executive session, and directly into what Mr. Armetti said about that in executive session before the judge's decision came down. And it may or may not be relevant to the board. I'm not trying to fight. If folks want to go into executive session, fine. And if they don't, I won't be able to participate, but that's fine. I'm certainly not trying to push the board one way or another.
If that's what it is. If that's what
We do
that
want
is.
to discuss it with him, okay?
Let them discuss it in open meeting.
So,
What do you,
We're all adults.
May I make a comment?
no, no.
I don't mind either.
May I make a comment, sir?
No.
Does it
It's
really
real
this
sh-
matter?
It's real short, yes it is. People on both sides of the issue are here to listen to the debate and to hear what's to be said. And I think it's imperative that this board keep this meeting open so that the people of this town and people outside this town who have interest in what goes on in this town can hear what's being said. Like you said, there's been no appeal, there's no litigation in place. However, if you do go in executive session, I do want to warn you, I will foil the executive session and I will take it to Ken Cameron and to Rob Woodley. And I think if you go into executive session with a lawyer, I think the person that brought the lawsuit should be allowed to stay in the room for the executive session, even if you get the rest of us out.
Give me your name, please.
Mr. Furman.
Victor Furman.
That's a good idea.
Okay, I need to repeat that any council person has the prerogative to make a motion. There can be a second, there can be a vote, and on that basis, an executive session is going to be called. If that happens, that will be respected. If that doesn't happen, then this will be an open session.
I think I would make a motion that we at least go into executive session to talk with David about our options, whether we come back with any decision or not. We should at least hear what he has to say. If he cannot say what he needs to say in open session without violating rules, then we need to hear what he has to say in executive session. So I'll make a motion to go into executive session.
And I'll
Hear what he
second it.
says.
For what? Oh,
For litigation.
okay.
Okay?
Discussion.
Sure, discussion?
I would like to have it recorded, please, that it's been advised that this is an improper move to an executive session.
I think that's a matter of opinion, isn't it?
It's been advised,
I don't want
that's what I said.
I think that he
Time will
also-
tell.
I think that he also made mention that he could see that this would be a reason worth doing so.
No, I didn't hear that.
Well, he's sitting right next to you, John.
My suggestion, my advice is that going into executive session on this particular issue for what's been stated so far would not be prudent. And it's gonna subject us to a possible lawsuit where the town could be liable for attorney's fees.
There's a motion and a second on the floor.
So when we're talking about attorney's fees, what are we talking about in regards to the town? I mean, we have to obviously be fiscally responsible. So
Right.
What are we looking at?
Well, there was an attorney in Springfield, it was in the paper last week, that was awarded attorney's fees in a Delaware County case for being successful in his argument that the town, I believe it was either Harpersville, went into executive session improperly.
You know, Mr. Slotzy had, actually, I understand he's already furnished you, or us, the options that he sees available to you. I mean, if there was something else to be said, why isn't it in writing and correspondence and we can digest that? Why do we need to go into an executive session on it?
Well, what we can do then is we can.
I mean, is this some big secret that needs to be sprung on us and?
We can withdraw the
executive
motion
session.
and then we can just make a motion that we would like to appeal the judge's decision, right?
You can do that?
Yeah, you can do
I
that.
think that's what we will do then, okay? We say, Bill, we withdraw the motion, and I'll make the motion that we go ahead and have David do the appeal against Judge Lambert's decision.
If you're gonna do that, then I call for more discussion.
Make up your mind.
So that's a whole different,
You can't have it both ways.
and we already have a motion on the floor.
Well, and she just asked me, and I said, I will withdraw my motion.
Now, we
Okay.
will second.
But there's, now, just so we're clear, there's a motion on the floor to appeal Judge Lambert's decision, is that right?
Right.
Okay, and now we are having discussion.
There's no second.
Okay, is there a second on it?
I will second that.
Okay,
And call for discussion, please.
okay, discussion, first from board members?
I have some things I'd like to say to that. First of all, I was hoping that at least one member of the board would come to the conclusion that we should not be going into an appeal on this. I was hoping that at least one other one would say that, particularly the ones who sponsored the moratorium in the first place a year ago. In the hopes that we could put this matter to rest, but evidently that's not going to be the case. So I didn't really care to get into all the reasons why we should not go into a moratorium either, or excuse me, where we should not appeal the determination made by Judge Lambert. But I would prefer to just reach a point where we put this matter to rest and not pursue it any further. But that's pretty apparent that that's not going to be possible. So I think it's important that we review the reasons why we shouldn't be going into an appeal. The town of Sidney and Mr. Slotsky created the moratorium. I felt it was bogus at the time. I said so at the time. In the first place, it wasn't a moratorium anyway. It was a ban disguised as a moratorium. They did nothing to prepare any kind of legislation in the year before that moratorium. They did nothing to prepare any kind of legislation or prepare for anything in the year since the moratorium. They were told then by more than one person that they're off base, that they're inviting a lawsuit against the town, that they were not following proper procedures to enact the local law, that for at least 2 reasons a supermajority was required. One, because the Delaware County Planning Board had made a recommendation not to pursue the moratorium. And secondly, there was a petition signed by more than 20% of the landowning voters in the town that was submitted, and that petition in itself should have forced a supermajority being 4 members. That was not considered, and in spite of those, at least 2 requirements to go in to have a supermajority, you went ahead under the guidance of Mr. Slotsky to pass the moratorium anyway. It wasn't going to cost the town anything. It's a free lunch. Well, as a result of this local law, local landowners had to pay money. Those are the people that pay the bills around here, the landowners, the real estate owners. They incurred expense. They had to take the matter before the judge. Who are we representing?
Right. There should be no comments
Who are you
back
representing?
here.
They had to pay to challenge the action taken by the board on this moratorium. It went before the Supreme Court. And it had to go to the Supreme Court in order to prove that the action was improper. And now we have Judge Lambert's decision. Now, that kind of overrides everything that we said, I guess. We now have a judge's decision that in fact it was improper. And don't hold me to the improper statement, that's not a legal term, but I think you understand what I'm saying. Mr. Slotsky was quoted in the Binghamton Press as in, having said in June of 2013, he called the lawsuit patently ridiculous, specious waste of judicial resources. That's his opinion of the lawsuit. If they misquoted you, then I misquoted them quoting you.
That's right, I read it.
Are you asking me to respond to that, sir?
Is it correct or not?
I'm not the only lawyer in this room who felt that way.
So it's correct.
Yes. And I still feel that way.
As I indicated in the debate when the question came up for the last election, as far as I was concerned, what this lawsuit was is a shame. I think it's a shame that we have to expose our own taxpayers to taking on a municipality in order to get the record straight and to right the wrong. So I think it's shameful that this has all taken place to this point. What else has this moratorium cost us? It's costing us time. We're spending way too much time on this moratorium. We've spent way too much time on it already. I'm talking about us, legislative time, administrative time, town taxpayer time, time that could be better spent. And I'm prepared to recite a list of the things that we should have been doing when instead we were worrying about a moratorium. I'm not sure I'm going to get to that. Except to say that we should have been paying attention to the budget instead of wasting time on a moratorium. Maybe we could have prevented some of the expenditures, the over expenditures that we experienced last year. Maybe we could have adopted a local law on protection of our roads, which we didn't, which we don't need a moratorium for. We can just do it. Maybe we should have gotten a grip on the hospital situation. So it wouldn't have been insurance I'm talking about, so we didn't have to have a special meeting over a Christmas vacation in the 11th hour because that hadn't been handled timely.
We need to-
Maybe we wouldn't be starting out in the hole on $3,000 in the hospital insurance budget, which was avoidable
None of this really.
if everybody was on top of it. It's time that should have been spent on something more fruitful.
At this point, you're just kind of slinging mud. I respect.
I'm
what
telling you
you're
the
trying
things
to
that we
do.
could have been doing, and I'll
Right.
stop at that
Right.
on those items,
Okay.
but I'm not done.
I would like to just respond to the conversation with this.
I'm not done. You can respond,
Okay,
okay?
sure.
I don't know why we're using the town of Sidney as a battleground for other people's issues. I don't think this needs to be dealt with here. There's no point in authorizing an appeal because there's really nothing to be gained by it, from my way of seeing it. And I guess, Mr. Cordes, maybe you need to tell us, what will we gain by going to an appeal at this point in time? You've got a local law that is dead in the water, it's invalid, it's nothing. It expires on its own terms. I think it already did expire on its own terms.
14th, right? Yep.
Um, Are we talking about an appeal in order to make it so that it is still valid? By the time it ever happens, it's already run out. It doesn't make any sense to me to go to an appeal. If you did, I can't even conceive of how, if somehow this thing were appealed and was successful somewhere down the road, you still need a supermajority. Now, you can never count your chickens before they're hatched, but I don't think you have a supermajority. And again, makes the whole thing futile, a waste of time and money. Now, it's my understanding, and the legal guys can correct me on this one for sure, but this one was, never even got out of the blocks because it was not done properly. But had it gotten to the moratorium, it never really got to the issues of the moratorium itself, only because it was deemed invalid before I got to that point. But there was a similar court case in Binghamton. Are you familiar with the court case in Binghamton? Everyone?
Of course.
Okay. Do you know why that one was defeated? Do you know why?
Why?
Do we know?
Yeah.
You do?
Yeah, but go ahead and tell us, John.
No, I think it's important whether you know.
Can I respond at this point?
Well, if you don't want to respond to that, I'll tell you that, as far as I know, my information is that it was defeated because there was no dire necessity, which sounds like, as far as I know, that's a key element in order to get a moratorium in the first place. There was no dire necessity, there still isn't. And it got thrown out in Binghamton for that reason, and now what? We're gonna do it here? And we think if we get through the other obstacles, which I don't know how we could, but now you think you're gonna get a dire necessity determination on a moratorium in Sidney? I don't think so.
Okay, John, I think we need to conclude it there, and I think there were some responses that were needed from the gentleman. You felt like make a response?
Yeah, and I'll keep it brief, because obviously unfortunately, this whole issue has become extremely divisive, and I think that this falls under, your opening comments as far as people being passionate about their views on it, and potentially saying things that are uncalled for and unprofessional. So I'm saying this as professionally as possible. I feel that some of your comments just aren't good journalism. They're not down the middle. I certainly understand your position, and viewpoint on those, but I don't know if it's necessarily the whole truth or sometimes all of the truth. And so I would just kind of leave it at that. You know, I think you've made it apparent that you are not for our position, and I respect that.
Would you explain why, what you expect to accomplish? Explain that, please.
Well, I do believe that it was done properly. I believe it was done.
Folks, please,
Okay.
please, please,
I do believe that, you know, we acted under counsel, not only from attorneys, but from advice on the state level. And I believe that the decision that the judge handed down really didn't take all of the evidence into consideration. And I just think that it's an important conversation to have even beyond Sidney. You know, I think obviously it affects everybody in this room and everybody in this community and that surrounds us in one manner or another. But I think it's a much louder voice than what we're dealing with right now, and it deserves to be heard. And if the decision comes back against us, then, you know.
Toby, you didn't answer my question. I said, what do you expect to gain? What do you expect to accomplish by going through this? I mean, you can disagree with the judge, you know.
Yeah.
A lot of people disagree with him, I guess, although,
I think I explained what I.
no, I want to know, where do you think this thing is going?
Can we move on?
Yeah, I would agree.
Oh, you're avoiding my question.
No,
I want to know what you
This
expect to
gentleman's
accomplish
videotaping. Go ahead and watch the
appealing a
video.
decision that's already dead and expired.
John, I explained it.
In theory, the.
I'm sorry, can I say something?
Hold on.
Yes.
Pete, I think you made the motion, or you want to comment?
Mr. Cordes,
He wants to
Councilman
know
Cordes, Councilman?
why we're doing this. Because we have a lot to lose if they come in here and start drilling and fracking. Because in this area, the gas is not very deep, so it makes us very susceptible to problems, okay? It's only like about 2,500 feet deep into the Marcellus Shale. And whereas in most places, it's like 5,000 to 7,000 feet deep. So you got a lot more safety in there if it's done right. And even then, if it's not done right, you can still have a problem. But that's why we're doing it, is to make sure that we don't lose our good water and our nice place to live here, okay?
That's why you're doing what?
Want to have a moratorium, that's why.
Okay, your motion, Pete, is to appeal, or, is that right? You're
Yeah.
appealing the present decision of the judge, that's the motion, is that right?
Right,
That's what was seconded, is that right?
right.
I think as a matter of discussion, David has something to say about whether we do an appeal or not.
Right, before you vote, many of the issues that the councilman raised are precisely the things that I wanted to talk and have written notes that I would have left, things like imminent crisis and things like that, had we gone into executive session. I'm not going to talk about those now. Before you vote on the motion, I would respectfully just ask you to consider, my advice is that unless you think you've got 4 votes, and the councilman has made it pretty clear that you won't, again, saying that you don't count your chickens, my advice is that you not appeal under these circumstances before you vote.
Thank you.
Done.
There's a motion and a second on the floor.
You know,
Yeah.
I'm going to respect Mr. Slotsky at this point, so I'm going to remove my second at this point.
You know, and just for the record, I do find his arguments meritorious. I find both sides' arguments legally meritorious. And this could have come down either way, as far as I'm concerned. So I don't believe anybody's engaged in any type of frivolous litigation here. I think 2 good points were made. The judge made a decision that happened to go one way, could have went the other way. So I don't want anybody to get the impression that anything that was done here, in my opinion, from what I read, was in any way frivolous or bad legal craftsmanship. I thought both sides did a very good job in briefing and arguing their issues.
I have one question for David. Since the moratorium actually is over, per the dates that we had set, and you're suggesting we don't appeal, what about an option of resubmitting to the county for a review, doing it the proper way, and hope we get 4 votes when it comes back?
Given what I've heard today, you have that option, is the answer. But given what everyone, some people on the board have talked about, use of time and things like that, I'm not sure it's a productive use of your time if there's not a reasonable probability that you've got 4 votes.
Well, you don't know that.
Yeah.
What about the executive
Saving
session?
saving time if we have this conversation.
No point.
True.
There we go.
It's time.
Well,
Fix the potholes.
Yes.
Could I ask one
Let's put it
question?
to
Don't
bed.
spend my money on
Vote it.
litigation.
Okay, we have one more question coming
Pay
from the
enough
floor.
money.
I'm just curious, because when this whole discussion started, there was a comment about there was a number of options available, but nobody actually mentioned what those options were. I'd just like to know what the options available were that were listed in whatever correspondence.
I'll be glad to read them for you, and these are from your letter, David.
Yeah,
Thank
and
you.
that's up to you if you want to do that. You might talk to Mr. Mehdi first. I think, I don't know what letter that is, but it's what I think it is.
Okay,
The first-
I'm just responding to a request.
The top of it says privileged and confidential. But
Sit down. He had his day in court long ago.
Yeah, I don't think we should discuss those in an open session.
Oh, yeah, I'm sorry.
Okay, thank you.
Okay, the motion's been withdrawn.
Executive session.
Let it go.
Some things.
No, executive session.
Go into executive session with it.
I would move that we put this matter to rest.
Go to executive session with it.
I think we've heard enough, and I really think it's time to, I really think it's time to move on.
Go into executive session with it.
We can't, Albert.
Okay,
I think it's time to move on.
okay, we're moving on.
Move that we do not pursue any further action on this, and that we thank Mr. Slotsky for his effort. And that unless and until we wind up with any kind of a backlash, which I don't expect, but in the absence of any backlash on this thing that we have to defend,
How
I
do
would
we
ask
know
that
we don't have 4 votes on the
let
board?
Mr. Slotsky, we can relieve him of his duties.
Is that a motion?
Yes.
Motion to not pursue any other action on this matter as far as the moratorium?
Because I think we need to take action. And I will renew my motion that says we go into executive session. And here we go.
Before we do that, there is a motion on the floor, which I would second. We need to have a vote on that. So, all in favor of
Yeah.
the motion?
Well, before you vote, can I just say one more thing? We have a person in the audience here tonight who I personally think we owe an apology to for what we put her through, and for that matter, other landowners. I'm not looking for an apology, that's not my point, really. But I think, I just want you to know that there is a person here in the front row who saw a problem, saw what was going on, saw that things were not being done correctly, and put her money where her mouth was, to put it that way.
Her name's Zephyr.
I think we should at least recognize that we're affecting people when we're doing this.
I think that's exactly what's going on.
You know,
I
there's a
think
whole
you-
bunch of
you should offer
landowners
an apology to
Okay,
the
I
other
out there.
I think there are many
landowners.
people that are gonna feel strongly about this, and many people are gonna be hurt no matter which way it goes.
I suppose that's true.
So, while I hear that, we still have a motion on the floor, which I seconded. We now need to call for a vote as to whether it will be accepted or not. All in favor of John's motion?
If there's something about it you want modified, let me know.
I think. Okay. The yeas are 2, yours and mine. Those opposed?
Yay.
Okay, please.
That was a yay?
That's a nay.
We're against it.
Right. Okay. Albert, can it be brief?
Yes, it's very brief. At the debates, Mr. Wodashek stated that our existing zoning laws were what gave people an inkling what they could expect from buying property in a certain area. This moratorium is to protect the existing zoning for Sidney. You are, by enacting a moratorium, protecting the existing zoning laws and the people of this town from a industry that now has 4 incidences from 4 different states of poisoning of water from that activity. So I would beg the board to protect the citizens of Sidney and the zoning laws that are already in place and continue on protecting the town by enacting a moratorium.
We've gone all through this before.
For Mr. Wodashek himself, zoning laws give you a clue as to what you can expect when you buy property. And I know many landowners that bought property here based on the rural and agricultural zoning of Sidney.
Okay, now.
Identify yourself.
First of, yeah, I'm Inge Grafikitler. First of all, I pay taxes here.
So do I.
So do I.
Okay,
Come on.
I don't think the town should listen to somebody that is only emotional. He just.
You don't even live here. You don't even live here.
He talks only about things that he believes, that are not the truth. So I told Mr. Slotky this in Bessel, and I told the Bessel town board the same. I don't think the town board should listen to people that are only emotional. That is Mr. Slotky and that is Albert. And I pay taxes, and I think you have the responsibility to do with my taxes what's important for the town. No water gets poisoned because I
Right.
tell you something.
Then what are the water buffaloes
Wait,
all over Pennsylvania?
Wait, if I have a property and I poison my water, then I'm in the same boat. Why would I do
You don't
this?
care. You don't care.
Listen,
Nick,
We've been through all this before.
look,
You're looking at the money, honey.
look,
Every bit of this before.
look,
Okay.
you don't know what I care or not.
I know.
Yes, you know,
I
okay,
do.
that's good, that's
You can tell by
fine. It's
looking.
wonderful that you know what I
When they were doing the
But
moratorium.
I want the board to listen to the people that have the land and not the people that have a half an acre, okay? I'm
Yeah,
sorry.
We have 70 acres, ma'am.
listen.
Yeah, would you identify yourself and tell me
I
who
just
you are?
said it again.
I did not hear you. Would you do it again?
I
Please,
said
tell
my
me where you
name
live.
is, I live in Jeffersonville and my property is here in
What's your name,
Sydney.
please?
So you
So
wouldn't
what-
live
so you
here.
have two persons?
I lived here, I used to live
So
here.
you're a resident
Until I got-
of Jeffersonville.
No, I'm a resident
Gentlemen, we
here
have
too.
one person
You are?
speaking.
Yes. That's it.
Thank you. Let me just respond in part by saying, this board will listen to all people,
That's wonderful, but not emotional ones, I hope.
all people. Right.
How can you not be emotional when you have worked your whole life for your property? You buy your dream house, you go to a town where the,
Funny?
Listen,
kind of funny.
where the comprehensive plan says that it's for very light industry, it's for farming, it's for agricultural. So you decide to live here. How can you not be emotional when that has the potential to be threatened? When you have the potential to lose your water? I think everybody has a voice on this topic.
I think you had a motion.
I would like to, since, in fact, Joe had said the things that are in that letter that you were going to read should not be discussed in an open meeting. I believe we should go into executive session, hear what Mr. Slotky has to say, hear what this letter has to say, and make a decision when we
Bill,
come
we
back.
already heard that. You already heard Mr. Slotchys tell you that
Make
he
the
doesn't
motion.
feel you should pursue the moratorium, and he doesn't feel, am I
No,
right?
No,
Doesn't
he
feel you
said we
should,
should not pursue
an appeal,
appeal, not the moratorium, an appeal,
right?
so.
The way I heard it, he said, the moratorium as well, without a supermajority.
Oh, that we don't have a.
Why don't you ask
I
him?
admit that, but
Is that what you said?
What I don't know what I said, but what I meant to say, what I meant to say was that in the event that you don't think there's a reasonable probability that you will get 4 votes, you should neither appeal nor pursue the moratorium.
Should they go into executive session?
for what? And shouldn't we, yeah, what's the point? We should put it to rest. Yeah.
There is a
And
motion
move
on the floor.
I make a motion, we go into executive session, hear what David has to say, and hear what this letter has to say. Which Joe already admitted we should not do an open session.
Yeah, my job is to protect the town, so, number one, I don't wanna see us get involved with Mr. Camlet and have to pay attorney's fees for improperly going into an executive session. Number two, my responsibility in protecting the town is in not disclosing a confidential communication by an attorney who shares the same status as I do on this issue. So, if you wanna take the risk,
Take it.
Let me say one other thing before you decide, including executive session. An appeal will require 3 votes, not 4. But one of the things I would have told you in executive session, one of the things I'll say here, is that I don't think you should do an appeal unless you got 4 votes committed to the long haul. Having nothing to do with the merits of the case, I'm absolutely convinced that the judge got it wrong on everything he said, and would love the opportunity to correct that, but I don't think this is the place to do it. Different situation if, as and when there are 4 votes. I would be happy to go in with you if that's the way you go, but given that Mr. Armetti has said no, given that you don't have the 4 votes, respectfully, I don't know if it's a good, productive use of your time.
Thank you.
Can I say just one little thing about a moratorium in New York State? There already is one.
Right.
So I don't see another one. Shaw hasn't gone through the environmental thing yet. Como hasn't made a decision yet. They'll probably start drilling in a couple of years in the southern border. They'll be here in 7 to 8, 10 years possibly. In the meantime, you can look and see what happens on the southern border. I think you're wasting your time. Come back in 5 or 6 years and get it straightened out. And for Pete's sake, put vertical back in. Thank you.
Thank you. We still have a motion on the floor.
And we don't have a second. So
Why have a moratorium when you got
Okay?
I guess it's still
So
no.
I'll second Bill's motion.
Okay. All in favor of going into executive session?
I,
no.
Let the record show that there's 3 yeas, there are 2 nays.
That's the advice of both attorneys saying not to, correct?
Well, I didn't hear him say no, I mean, that
He
was.
just said no.
Yeah.
Joe told you no, he just told you no, why did you ask?
Just said no.
It should be noted that,
voted.
in my opinion, for what it's worth,
You know what it's worth.
it's not a legal opinion, but it appears to me that this is
Well,
an
if we're-
improper
If we're gonna discuss
executive session.
confidential stuff, then it should be done in executive session,
Well,
Yeah.
not an open meeting.
Ladies and gentlemen, will you please excuse us?